Thank you, my lord. Perhaps we could either swear Dr. Gikonyo in or affirm.
Good morning, sir.
My lord, good morning.
Good morning.
We were also served with this about the replying affidavit to the doctor's affidavit, one by Mr. Kindiki and the clerk of the Senate. And also being petitioners in these proceedings, Your Lordship, I'm seeking your guidance, Your Lordship, as to the participation of other petitioners insofar as the affidavit by Mr. Kindiki and Mr. Nyengenye is an issue. Otherwise, our quorum is as before.
My lord, I don't understand the basis for the direction being sought from you, because you already gave the direction when we were before you that any party who desires to cross-examine the witness now on the dock would do two things. First, they would file a reply to that affidavit. And number two, in that reply, they would intimate whether they wished to cross-examine the witness now on the dock. Mr. Ndego Njiru cannot now purport to be ignorant of those directions, having not done what you directed should be done by anyone desiring to cross-examine this witness. Then he can't come here and just tell you we seek direction on what other petitioners should do.
Thank you for that, the direction which Mr. Ndegwa has sought. I think directions which we gave last time are very clear. For you to find or found a basis for cross-examination, you must have responded in one way or another. So if you have filed an affidavit, I'll allow you to participate. If you have not filed, unfortunately, you cannot go back.
Thank you, my lord. We will proceed.
Say aye.
Aye.
Your full names.
Dr. Dan Kibuka Gikonyo.
Swear by the Almighty God.
Swear by the Almighty God.
The evidence I shall give to this court.
The evidence I shall give to this court.
Touching the matter in question.
Touching the matter in question.
Is the truth.
Is the truth.
Nothing but the truth.
Nothing but the truth.
So help me God.
So help me God.
Please state your full name, profession, and your professional qualifications.
My name is Dr. Dan Kibuka Gikonyo. I'm a medical doctor, qualified from the University of Nairobi in 1975. I hold a master's degree in internal medicine from the same university. I'm a fellow of the American College of Cardiology after a course in Minneapolis.
Dr.
Yes,
you are giving evidence in court. So we want to hear what you are saying and record it.
Speak loudly, Dr. Gikonyo, so that their lordships can hear you easily.
I believe it's a microphone, not me, sir. But I'll proceed. My voice is quite clear. It's a microphone. The technology, if it's okay, then can you hear me now?
With the permission of the court, Perhaps you could place something under the microphone to just lift it up.
Sorry, then it's my height. Is that better? Is that better? Your Honor, again, my name is Dr. Dan Kibuka Kikonyo. I am a medical doctor, a graduate of the University of Nairobi, 1975. It's 50 years last August. Postgraduate internal medicine, the same university, 1980. Thereafter, fellow of cardiology, and now a member of a fellow of the American College of Cardiologists, trained in Minneapolis and the Mayo Clinic in the US up to 1985. Now practicing at the current hospital, previously a lecturer at the University of Nairobi.
Thank you. You have a document titled Affidavit,
Your Honor, I do.
shown on 28 April 2026, consisting of 12 numbered paragraphs. Do you recognize this document?
Your Honor, I do, and I do have it.
Whose affidavit is it?
This affidavit, Your Honor, is mine, Dr. Dan Kikonyo.
Whose deponent signature is on page 3 or 5 of that affidavit?
That signature, Your Honor, is mine, Dr. Dan Kikonyo.
Do you wish to adopt the contents therein as your evidence in this matter?
Your Honor, I do.
Please tell the court whether you are acquainted with any party before these proceedings in a professional capacity.
I believe by the party you mean the respondents. Yes, I'm acquainted with my patient, Honorable Gachagua, whom I have taken care of. From my records, Your Honor, my hospital records that I do have with me, I have been a doctor to the said Honorable Rigathi Gachagua since, if I could, 5:10 p.m. on the 10th of July 2006.
Okay. When and under what circumstances did you meet the first petitioner, if at all, during the period in issue and relevant to these proceedings?
I believe for the purpose of this issue, you are referring to his hospitalization at the current hospital, which again, from my records, handwritten notes, happened at 3:25 p.m. on the 17th of October 2024, Your Honor.
And what happened when you met him? What happened next?
Your Honor, the reason for his coming to hospital, he called to say he's on the way with chest pain, and we received him and acted accordingly.
From your experience and expertise as a cardiologist, what significance do such symptoms have?
Your Honor, you know, chest pain has two categorizations. There's chest pain that can occur if you are going to have a heart attack, medical terms called myocardial infarction. That, when you say you have chest pain in that category, we look at the possibilities of that being real, as what we call the risk factors. And here's a man at his age.
Madam, my lady, with a very kind permission. With a very kind permission. I have listened to where the evidence, my lord, is headed, and in my very humble view, we appear to be expanding the scope of the petition and the affidavit that is before you, Lordship. Madam, it is important that we stick to what is in the affidavit for purposes of, that is why we are here today. If we attempt to then expand it beyond what we agree, then we'll be prejudiced. We'll have to find further affidavits, etc., to be able to respond to the questions that are being raised. We must, I submit, stick to that.
You have filed an affidavit in this person?
We have, on behalf of the Senate.
My Lord,
yes.
if I may respond, I would refer the court to paragraph 5 of the affidavit. Basically, the questions are formulated based on what the witness deponed to. Unless they specifically state exactly what is new, my lord, we request that you do allow the witness to proceed with his testimony.
Laying a basis does not presume introducing new issues by way of evidence issue. It doesn't mean you then introduce new technical issues that we need to deal with. Who would have to respond?
I think the way forward is, Ms. Waigua, you'll refer the witness to particular paragraphs of the affidavit.
You do have the affidavit with you?
I do have it, Your Honor, in front of me.
Okay. Please clarify what you meant under paragraph 5 of your affidavit.
Your Honor, paragraph 5 asks, based on my professional expertise, what do these symptoms mean? That, Your Lord, is what I understood. My answer to that is that, based on my experience, those type of symptoms, depending on the probability of disease, which depends on your risk factors, would imply that you could be having a heart attack. That is my simple answer.
And based on paragraph 6 of your affidavit, what role or steps did you take with respect to the first petitioner having been presented before you?
Your Honor, if a man of that age and risk factors presents, there are standard protocols that we follow in medicine to evaluate that person. In this particular person, I must admit, there was additional risk factors of stress. And stress has got its own problems of affecting the heart in a condition that we call the Takotsubo syndrome.
I refer you to paragraph 7 of your affidavit. Please clarify what you meant in that affidavit on paragraph 7.
Again, Your Honor, in medical practice, and it is standard that can be confirmed from all parts of the globe, if somebody presents with chest pain in hospital and has necessary risk factors, you are then hospitalized for evaluation to see the extent and the dangers at which this poses.
What examinations did you conduct?
The examination, again, Your Honor, are standard. Apart from the physical examination, taking a proper history of the circumstances, then you proceed with specific tests, which includes what we call a tracing of the heartbeat, for purpose of this court, called an ECG, an ultrasound of the heart, for this purpose of layman's terms, an image of the heart, and blood tests to check for any heart muscle damage, which again, Your Honor, is all standard.
Madam, very kindly, as my Lord did direct, could we be pointed to specific parts of both the affidavit and the attachments that then align with what the good doctor is saying? My concern is one, we, by seeking clarification, we are then proceeding or extending beyond what is contained in this document. It then leaves us in a very precarious position.
I think that the doctor is here to give us expert evidence, and we must give him the room to give that evidence.
Yes. Can we clarify, my Lord, beyond that contained in the affidavit?
We note this.
Yes. My Lord, if I may assist the court.
Yes.
The issue being raised is we have a written affidavit, which is sworn testimony. Ordinarily, that would be the evidence in chief. The second issue is that it is trite that where a thing has been reduced to a document, in this case, the affidavit, and the annexures thereto. You cannot, under the guise of examination in chief, purport to add to subtract from, to contradict, or vary. Even if this witness were to spend 2 days here, it's just a waste of your time. Section 99 to 101 of the Evidence Act says that evidence is inadmissible.
I think
this make a very brief reply. The rule of objections, as I know them, is that you object to something, objection irrelevant, objection something. There's no specific objection. You're being told that the objections, without a proper basis, we kindly request you to order that the examination in chief proceeds and concludes very shortly. Then my learned friends would have their time to impeach and to do anything lawful with the witness on the stand. Thank you, my lord.
Ms. Waiwa, you will proceed with the latitude that those paragraphs in the affidavit gives you. And I think we must understand that we have an expert witness. There's a reason why we call him an expert. He has come to tell us something we may not know. Therefore, within that latitude, please proceed.
Thank you, my lord. So, what you are referring to was in paragraph 6 of the affidavit?
Your Honor, exactly. That's the point. And the things I've mentioned are in that affidavit, the ECG, for the sort electrocardiogram, the echo, and the blood tests. I've not gone outside that context. Your Honor.
Thank you. Please refer to paragraph 4 of your affidavit and annexure marked DKG 3. Annexure marked DKG 3. Can you explain the timings reflected in those documents?
Your Honor, is that point number 8?
Paragraph 4. Paragraph 4
Your Honor, is that...
of the affidavit,
Yes.
which talks on when you approximately met the first petitioner.
Oh, I've seen it now.
DKG.
Thank you. Yeah, Your Honor, as I mentioned earlier, that was on the day of admission, which we just clarified just now from my handwritten notes of the hospital notes, which was on the 17th of October 2024 at 3:05 p.m.
No, my lord, now the witness is confirming why you are hearing objections. The witness is referring to his handwritten notes, which are not attached to the affidavit.
My apologies, Your Honor. I will not refer them again.
Okay, please refer to paragraph 4 of your affidavit.
Yes.
And annexure DKG 3.
Yes. Yeah.
That annexure is titled Discharge Summary.
I think you should have somebody to assist the doctor.
Yes.
So that we know exactly what point we are on at.
Yes.
Please not this one there.
And there are timings mentioned in paragraph 4 of your affidavit.
Yep.
And there are timings indicated in the discharge summary. Could you explain those timings?
This date. And the date of admission, the date of discharge, would that be the issue? Your Honor, this is the day of discharge, the day of admission is the time that the patient was admitted to hospital. As I mentioned earlier, it's written here as 4:18 p.m. I would qualify that, Your Honor, that we must understand what admission date and time.
No, my lord, that's exactly what the law says the witness can't do.
Yes, that one can't do.
I can't explain.
You can,
No, Your Honor,
what you should try to avoid is any interpretation of the document outside the document.
No problem. Admission time 4:18 p.m., 17th October 2024. Discharge 20th November 2024, 1:36 p.m.
Okay, under paragraph 4, there is a timing of 3 p.m. What transpired at that time?
3 p.m. is the time of admission that the patient arrived in the hospital and was duly attended to.
Just a clarification. 3 p.m. and there is the 4:18.
That's what I was going to, and I was stopped from saying, Your Honor.
Please clarify this.
If I'm allowed.
What happened at 3 p.m.? What happened at 4:18?
Exactly, Your Honor. That's the
My Lord, we still retain the objection. It is in black and white in the Evidence Act. If it is in the document, no amount of oral evidence from this witness can be admitted for purposes of adding, subtracting from, clarifying, or all these things is now purporting to.
Your Honor.
Let me rephrase that, Your Honor, and because the times you've read them out, when did you see the patient? What time did you see the patient?
3:25.
As per paragraph 4 of your affidavit.
Yeah.
What time did you see the patient?
Approximately 3 p.m.
Okay. What time was the patient admitted to hospital?
At that time that I talked about.
Which was?
3 p.m. But on the paper here, and you must allow me to clarify, because you have to understand why that date is there, or that time is there. That's why we are here, to explain to you the discrepancy between 3 and 4. Your Honor, if you allow me, I have an answer to that.
Just answer what she asked you, what the counsel asked you.
Yeah. Answer. Proceed.
The discrepancy is because as one comes to hospital, that is not admission. Admission is when the technical details are entered in the admission papers after all other factors have been taken. You put that time as the admission time.
Okay, thank you very much.
If there's no cover for that, you will not be admitted, even if you have been seen.
Thank you. Thank you, Dr. Now, refer to paragraph 8. Paragraph 8 of your affidavit. And the annexure again, marked DKG3, which is the discharge.
Your Honor, yes. On the first point that you raised, on the affidavit, we say he was discharged on the 20th of October 2024.
Okay.
On this other, it says discharged the 20th November. There's no error in that. If Your Honor allows me, I can explain why that is so.
Please explain.
The answer is, again, discharge process in hospitals involve accounting. You must pay before you are discharged. And even if you have been discharged by the doctor, and you haven't gone home and you have not paid your bill, you are technically not discharged. We call it an open bill. It's that when you come and clear all your bills and everything else, that you are technically financially discharged from the hospital.
Thank you. Refer to DKG3, the annexure, which is a discharge summary, at page 4 of 4. Who wrote the discharge summary? Who wrote the discharge summary? It's at page 4 of 4.
Your Honor, if you allow me, I have to define what we mean by writing a discharge summary. Because our hospital, current hospital, is a training institution. We have medical interns, we have medical registrars, we have junior consultants, we have senior consultants. And the typing of the discharge summary, printing on the computer, is done by either the medical officer, or the registrar, or the intern. In this one, it was done by Dr. Sarita. But the consultant overreads what has been seen there and signs that is correct. So it was prepared by Sarita, signed by me, Dr. Langikonyo.
Still on page 4 of DKG3 annexure, which is the discharge summary, what did you mean by the follow-up, that ongoing review, follow-up?
I believe in medical terms, what we mean by follow-up when you are discharged from hospital is that although you have been treated, there are issues that need to be followed up. How are you faring? We actually, at the current hospital, we actually call patients at home and ask them, you were discharged last week, madam, how are you faring? But in more than that, we give you an appointment to come back, just to make sure what we did was correct and you are feeling better. And if anything needs to be done, and then most of the time, you actually need almost a lifetime follow-up.
Okay. Is the annexure marked DKG3 to your affidavit true and accurate copy of the original discharge summary?
Your Honor, it is.
I'll go to the last bit. During the period the first petitioner was under your care, what communication, if any, did you receive regarding his condition from anywhere?
Well, Your Honor, there are always follow-up calls from relatives, parents, and friends. And in this particular case, Your Honor, I must be honest enough to specify that I did receive a call from our president asking about the status of the patient, and they responded accordingly.
What did you communicate in response to that inquiry?
Well, the first time, Your Honor, I just said that we are in the process of doing various tests, and as soon as we have a conclusion, we shall let it known.
Okay.
But if Your Honor, you must allow me to say this, that when I said that, I had to seek clearance from the patient that was okay so to do, which she gave me permission.
Okay, very well. On my second last question, please refer to paragraph 10 of your affidavit. Paragraph 10 of your affidavit. And annexure DKG4.
Yes, Your Honor.
And tell this honorable court the relevance, if any, of the annexures in relation to your testimony.
You know, Your Honor, during this hospitalization, this hospitalization for reasons that happened that time became a public issue, and there were public notices in newspapers and television services covering the issue.
Okay. Lastly, please refer to paragraph 11 of your affidavit, and in summary, what you'd like this honorable court to understand regarding the first petitioner's admission and treatment.
Your Honor, I have only one statement to make, and that the Honorable Gachagua was admitted to hospital on the date so specified and discharged on the date so specified and treated according to the statutory medical practices.
Thank you very much. That is all, my lord.
Thank you.
Good morning, Dr.
Good morning, sir.
My name is Mobomi. I think we know each other.
Lovely. Nice to meet you in these circumstances.
I will ask you a few questions
I'll be
on
pleased to
behalf
answer.
of the respondents.
Thank you, sir.
And the second interested party, who is the party I represent in this case. For the record, please confirm that your affidavit is dated 28th of April, the year 2026.
That is correct, Your Honor.
You will agree with me, sir. This affidavit has been made 1.5 years after the events described in it. Correct or incorrect?
Correct.
It's correct. Was this affidavit placed before the Senate?
I wouldn't be aware because it didn't exist that time. This request has come now.
The request has come now.
Yes.
You don't believe, sir, it is bizarre that a request of this nature in a case of this nature will be made 1.5 years down the line? Would you agree with me? That's bizarre. It's not natural.
Sir, I don't know the proceedings in court for those issues.
Fair enough. This affidavit has attached some medical records, Exhibit 3. Correct or incorrect?
Correct.
That exhibit, was it placed before the Senate?
I wouldn't be aware, sir.
You are not aware. But you will confirm whichever date we take from the multiple dates on it. These are again events that this document was available about 1.5 years ago by the date given this of 17th October, isn't it?
I mean, that is what is this? Yes, that's...
You have to agree this document was available.
Yes.
You also have to agree that with due diligence, this document would have been placed before this honorable court about 1.5 years ago. True or not?
No opinion, sir. I don't know.
No opinion? Fair enough.
Yes.
You have now attempted to explain a discrepancy between paragraph 3 of paragraph 4 of your affidavit. It talks of 3 p.m.
That's correct.
But Exhibit 3 at the top right talks of 4:18 p.m.
About an hour difference, yes, sir.
You agree that's a discrepancy on its face? On its face, without more looking at it, is there or is there no discrepancy?
None whatsoever, sir.
Are you saying 4:18 p.m. is the same time as 3 p.m.?
There are different times for different...
There are different times. Therefore, you agree with me, sir.
But could the witness be given the opportunity to complete answers to his questions without being cut short?
Dr. Gikonyo, is it your testimony that the time 3 p.m. given at paragraph 4 of your affidavit is the same time given as 4:18 p.m. in the medical record?
They are different
Good.
occurrences.
They are different times.
Occurrences. They are not the same thing we are describing.
Okay. This explanation you are now offering on the witness doc, is it given anywhere in your affidavit? The explanation for the discrepancy, is it set out anywhere in your affidavit?
It should be understood.
No, the question is it set out anywhere in your affidavit? That explanation you are now offering in court.
Not there because...
It is not there.
It was never raised. Had I to have been, I would have given an answer if it was
We
raised.
are here to raise it, unfortunately.
And we are given an answer.
Let's stick to that page 1 of 4. Dr. Gikonyo, you have to agree with me that we identify individuals in Kenya by reference to their national identity card or passport number. Correct or incorrect?
Depends on the purpose, sir. In my class, they call me DK.
Does this document indicate the identity card of the patient being attended to? Does it indicate the identity card number? National identity card number. Either it does or it does not.
We have the client's ID number in
That's
his
not
records.
my question, sir. My question is, on its face, Does this document disclose the national identity card of the patient it describes?
Deliberately not.
Good. Does it indicate the travel passport number of the patient?
Deliberately not.
Good. Deliberately not.
Yes.
Very good answer. Does it give the patient's name?
Deliberately not.
Therefore, you have to agree with me, sir. A document that does not contain the patient's name, does not contain the patient's national identity card number, does not indicate the passport number. We have no way, based on the document, of ascertaining who is the patient described in that document.
We do have, we can ask the person who prepared it.
No, the person on the doc is you. Does this document on its face, sir, disclose the identity of the patient described there?
Only by initials, RG.
RG,
Yes.
which could mean anything, isn't it?
To other people, but not to me.
Okay. Fair enough. I put it to you, sir, that you having brought this document to court, you cannot run away from the fact that it doesn't disclose the identity of your patient.
Deliberately so when it was prepared. But now I can disclose. If you ask me who it is, I'll tell you. RG.
RG could as well be Rob Gitau, right?
Could be, but it is not.
It could be Ruth Gitanga.
It is not. Ask me
I
what
put
it
it
is.
to you, sir, it can be anyone and anything.
In this category, no.
Okay, fair enough.
You can ask me who is RG. I'll tell you who is RG.
The problem is we don't believe you. That's why these questions are being asked.
You ask me, why did you write RG? I explain.
It is me who chooses, unfortunately, the questions to ask. So, let's go to that. The title of the document is a medical summary.
Correct?
You have to agree there is a difference between the summary and the primary document.
That's true.
So has the primary document been placed before this court?
I don't know.
Can you see it anywhere in your affidavit? You can take time to flip through.
Not on my affidavit.
It is not in your affidavit. You have to agree with me, therefore, in the absence of the primary document, an independent reader has no way of confirming whether this summary agrees with the primary document.
They can ask the writer who is in front of us here.
No, on the document, sir, we are dealing with the document. In the absence of the primary document, would the third party have a way of confirming whether the summary is accurate?
If that document was adequate in itself, I would not be here. I am here to answer questions pertaining to the document, to say whether it's correct. If it was adequate on itself, you wouldn't call me here.
We actually called you, Dr. Ikonyo, because the document has just too many gaps.
For me
Let's
to
go to
clarify.
the paragraph of your affidavit that talks of the 48 hours to 72 hours.
Correct?
That's paragraph 7 of your affidavit.
Correct, sir.
If that were true, it would mean this patient, and we mean patient RG, whose identity we don't know,
Which I can confirm.
it would mean that this patient would have been discharged on or before 20th October 2024. Correct or incorrect?
Or a month later.
We are following the document, sir. Your paragraph says he was admitted for how long? 48 to 72? Your paragraph 7.
Sir, please read correctly. Recommended.
And when does it say he was discharged?
On the 20th
Of which month?
of October.
Of October, good. And what is the discharge date given in the medical summary?
November.
November. That's actually 34 days later.
Correct.
Correct?
Yes.
You have now attempted in your exam in chief to explain the discrepancy.
Not attempting, I did explain.
Okay. Let's take it, you have explained. You have explained while on the witness dock.
Yes, Your Honor.
The discrepancy of 34 days, right?
Yes, Your Honor.
Is that explanation set out anywhere in your affidavit? The explanation you gave this court for that discrepancy?
Yes, this is understood.
No, my question is the explanation you are now offering 1.5 years later, is it said, show me the paragraph of your affidavit that explains the discrepancy?
It was not required.
It was not required. But for the record, is it given in your affidavit, that explanation?
Not given because not
Good.
required.
It's not given. This summary gives the consultants who are attending to the patient. Can you see that part of Exhibit 3?
I do, yes.
It begins with yourself. Who are the other doctors?
Your Honor, if you allow me to explain.
You can look at it.
I know it.
I haven't asked the question for you to explain. You can only answer questions I ask.
I know the names on the list. I can look
The
at
names
them,
given there.
Yes, I can look at them, but I know them.
You know them.
All of them, yes.
Is the maker of this document one of the doctors who are indicated as attending to this patient?
No.
No.
Do you need an explanation?
So we don't have the primary document, and we have a summary made by a person who did not attend to the patient.
Not correct.
Not correct. Is Dr. Sarita, just for the record, indicated as one of the doctors in this summary who are attending to this patient?
She is not a consultant.
My question is she indicated as one of the doctors who are attending to the patient? From the list given at the top, is Dr. Sarita one of them?
Your Honor, I must explain what this list of consultants mean to the audience here.
We are not interested in that. The question is she indicated? Either she is, and Dr. Wade, quickly, if you answer the question, the more we kick about the bush, unfortunately, the longer time it will take.
But I can't allow you, sir, to proceed on a misunderstanding.
My Lord, the witness has no...
Excuse me, Dr.
Yes.
You came here to give evidence.
Yes,
you
Your Honor.
answered questions as put to you by counsel.
Okay.
Without any
But Your Honor,
deviation. Just answer the questions as put to you. If you don't know, you say you don't know. Then we proceed.
And that's how the law works, Dr. Gikonyo, just for the record.
Thank you. I understand now.
So is Dr. Sarita indicated in this document?
Should you find that there's a need for clarification,
Yes.
they will ask you to clarify.
All right.
Yes.
Go on.
So Dr. Gikonyo, is Dr. Sarita, the maker of this summary, indicated as one of the physicians that were attending to the patient, known as RG? On the face of it, is she indicated in the list of those doctors?
Not as a consultant.
Is she indicated in any other way?
As a preparing, as the one who prepared the document, yes.
That's not my question. Just wait. Is she indicated as attending to the patient in any medical capacity? The maker of this document.
The people taking care of the patient are not listed.
I thought they are listed here, sir, about 6 of them.
Those are the consultants. There are other doctors in the system, medical officers, intensive care doctors, and other people. And as I mentioned earlier, we are a teaching hospital.
Is there any material you have placed in your affidavit to show those other doctors and the fact that they were attending to the patient?
No.
Good. In fact, on the document before the court, we have no way of knowing who else other than the 6 given that attended to the patient.
Only by asking the person on the dock,
No, we are talking on the document, sir.
not on the document, sir.
Good. Let's go to the bottom of that document. Bottom left. That document has a computer timestamp at the bottom left, correct? Bottom left, below prepared by Dr. Sarita.
That is right. 2011, 24, 1240?
12:40 p.m.
Yeah.
So what is the date and time of this document's preparation as per that timestamp? It is prepared on the 20th of November 2024 at 12:40 p.m. Correct or incorrect?
Right, that's correct.
Now let's go to the opposite side of the page, bottom right.
Yeah.
What is the date and time given? The date you confirm,
20 November 24, 12:35, 19.
12:35. You have to agree those are two different timestamps. Correct or incorrect?
That's correct.
You must agree, sir, that it is not possible for this document to have been prepared at two different times as it purports to say.
I won't understand why the computer would do that. I would have to check on the computer data.
Unfortunately, sir, you have to agree with me that on the face of it, this is a discrepancy as to the time when this document was prepared. It has two timelines. Which one do we take?
I do not know.
Good. You don't know.
I won't add that it would matter.
You have testified that this patient, at the prior history, we go to page 204,
Yes, Your Honor.
and you have summarized it there.
Yes, Your Honor.
Have you placed before this court any primary documents to prove this alleged prior past medical history?
If required, is available.
No, my question, sir. Have you placed before court any material to show that this patient had prior history of the conditions described there?
None at all, but if
None at all.
If
Good.
required, Your Honor, it's
None at all.
available. It's available. I have it on me here today.
Unfortunately, it's you who testified on affidavit on oath, sir, that he has past history. So you have to agree with me then, in the absence of that material on the record, this is just an allegation. We have no way, based on your affidavit, to confirm that the patient described there had this prior history.
You have no way, but if you are interested in knowing, it can be provided.
Doctor, you say you did a number of tests on this patient,
Yes, Your Honor.
including an echocardiogram,
Yes, Your Honor.
2D, one is called 12 LED and the other one 2D, right?
Yeah.
You must agree with me that that machine for echocardiogram generates a report and a graph, correct or incorrect?
Of course. Yes, it does.
Yes, it does. Have you in this affidavit attached that graph that the machine generates to show that the patient has the conditions described in the summary?
No, it's not. Available if required.
No. My question is, have you attached to the affidavit the report that the echocardiogram machine generates?
Definitely not.
Good. Have you attached the report that the other machine automatically generates?
Not attached, but exists.
Fine. Have you attached the images that were supposedly taken of this patient?
If I thought they would be useful for this court, I would have attached them. I thought it was not necessary to attach them, but they are available if required.
But you would agree with me that the images and the graphs and the reports would be the primary document evidencing the illness, correct or incorrect?
Correct.
Therefore, if that is correct, you must agree with me that this summary, in the absence of those images and those graphs and those reports, cannot be the evidence that patient RG had the conditions described in your affidavit.
Unfortunately, I would not agree with you.
Fair enough. You say he also took some blood tests.
Yes, Your Honor.
Have you attached the laboratory report of those blood tests to this affidavit?
If you are required, we can.
No, Doctor, my question
they
is...
They are not attached.
Have you attached
Deliberately
the
not.
laboratory report of the alleged blood tests?
Deliberately not. Available if required.
So again, based on your affidavit, you have to agree. We have no way of knowing whether there were blood tests or what were the results of any such blood tests.
I disagree. We have a way of knowing. You can ask me, I can produce them.
Page 3 or 4 talks of hemoglobin, platelets, and blood chemistry and other things. Correct or incorrect? Either it does or it doesn't, Dr. Ari.
It does.
Do we have in your affidavit the primary document, that is the laboratory report for all these tests?
Available if required.
No, my question is, do we have it in your affidavit?
Definitely not. They are not there.
Definitely not.
Yes.
In page 404, there is some information there about follow-ups. Have you produced before this court any document on that follow-up?
Has not been requested.
The question is, have you annexed it, sir?
No.
You have not annexed it. So again, I put it to you, there is no material before this court to confirm there was any follow-up. Dr. Gikonyo, in summary, you have admitted you have no material before court to show the prior history of the patient. You have confirmed there is no material before the court to evidence his medical condition when you supposedly attended to him. And there is also now no material of the follow-up. Is it not because this gentleman was in your hospital to hide away from the Senate? He was not sick. I put it to you.
Let me laugh a little bit first.
Trust me, I too have been laughing about it.
Sir, Your Honor, I must apologize. I must apologize. I must apologize, Your Honor, for that. I must apologize, Your Honor. But honestly, sir, if the question arises as to those documents that have been raised, if they are available, and if you are looking for justice and honesty, you can ask me to provide them. And it takes 2 seconds. They are here.
Yes, you may have them, but they are not on the record, sir.
You can have them.
Unfortunately, the law does not permit you, Dr. at this belated stage, to even refer to them, because they should have been put on the affidavit. But to my summing up questions, your affidavit alludes to some media coverage,
Yes, Your Honor.
of his alleged illness.
Yes, Your Honor.
Did you give yourself a press conference on this illness?
Yes, Your Honor, on demand from the press.
On demand from the press?
Yes.
Dr. Gikonyo, is it standard medical practice for doctors to give press conferences as to their patient's illness?
It depends on the sensitivity of the issue.
The question, sir, is it standard medical practice for doctors
Yes, when it's
to
required.
call press conferences?
No, sir, we don't call for press conferences.
Okay.
Press comes to us.
When you were giving this press conference, the case before the Senate was proceeding, correct or incorrect?
Most likely so.
You found time to give a press conference, but you didn't find time to go and tell the Senate.
Oh, no. In what capacity would I go to the Senate?
Good. Wouldn't the Senate, where the proceedings were going on, sir, have been the natural forum for you or any of your colleagues to go and tell Senate that the witness cannot come because he's been admitted in hospital?
I'm not sure if access to the Senate is available to every common person like me.
That's all from me. I will yield the floor to Mr. Mukele Melod to wrap up the cross-exam.
Well, there is a serious allegation in the form of a question raised by Dr. Thionkulu that Dr. Gikonyo was hiding the first petition. That was posed, and I'm not sure that Dr. Gikonyo was given the opportunity to respond.
Why don't you respond in your response?
Just for the record, the witness answered and he said his answer was to laugh.
We'll deal with it.
The process to deal with it.
We'll deal with it, yes. Thank you.
My Lord, Your Ladyship. Senior Counsel Dr. Piancolo has covered quite a bit of ground. I will only have about 3 or 4 questions for this witness. I don't think I have much to add. Good morning, Dr.
Good morning, sir.
My name is Edwin Mukele. I represent the third and fourth respondents. I've been permitted by Senior Counsel, Professor Ojeda, to ask 1 or 2 questions on behalf of the Senate.
Thank you, sir.
Now, I had your last comment to be that you are not sure, and this goes to Dr. Piancolo's very last statement, you're not sure whether you have access to the Senate. That's what I heard you say.
Yes, I said so, sir.
Now, Dr. Gikonyo, the affidavit that you presented before court is sworn on the 28th of April 2026.
That's correct.
That's correct. Do you recall when the first petitioner was impeached?
Not the exact date, but I believe the same day that he came to hospital.
The same day that he came into hospital. Would that be the 17th of October 2024?
Most likely so, sir.
Most likely. This is about, we then receive your affidavit in court about 1.5 years.
That is correct.
After he has been impeached.
That's correct.
Now, going back to your evidence, and I'll be very brief, my lord. When asked a question on whether the documents you presented would have been presented to the Senate, your answer was, the request has come now. That is what I had you to answer to one of Dr. Diakono's questions.
Yes, that's why I'm here today.
The request
sir.
has come now.
That's why I'm here today, sir.
So the request, Dr. Gikonyo, to file the affidavit and the attached documents has come now. That is what you said, yes?
Yes, I mean, yes.
From whom did you receive the request?
From the petitioner.
You received the request from the petition?
Yes.
Do you recall, do you know, when the petitioner first filed the petition? Might you know?
No, I don't. And I'm not interested.
You're giving evidence and you're not interested in the context of a petition in which you have no interest. Is that what you're telling the court?
Yes, sir. I'm here purely on a medical issue, not on a court issue.
That is startling, Dr. Ali, I must say. It means, in my view, you probably don't understand the reason you're here. But I will go on. You have also, and this is my last question, mine, very brief. You have also confirmed that you do not know whether the affidavit and the documents attached were before the Senate. Do you have any information on that?
Not at all.
You don't have any information on that?
And I agree with you, sometimes I really don't know why I'm here. Because my understanding is I'm here to answer medical questions about the petitioner in hospital.
So,
about law things and court and Senate, so I am ignorant.
So, Dr. Gikonyo. Dr. Gikonyo.
Yes, Your Honor.
You cannot tell the court, from what I understood, whether the affidavit and the documents presented today, sorry, the affidavit sworn by yourself on the 28th of April, were before the Senate at the time of the impeachment proceedings.
I wouldn't know. And
you only know.
Your
That's
Honor,
okay.
I have no interest in those matters.
That's okay. That's okay. We understand that you do not know why you're here. Madam, those are my very brief questions on behalf of the Senate. I beg to.
Thank you.
Thank you.
Dr. Gikonyo?
My Lord, we had Dr. Kamoto to ask just 2 questions, then the witness can be re-examined. If you permit him, please.
My Lord, there was no affidavit filed by Dr. Kamoto, and you have given directions before the commencement of this proceedings.
Let Dr. Kamoto speak for himself. Dr. Kamoto, did you file any affidavit?
Yes, my Lord, my lady.
Did you file any affidavit?
We have put our responses. We are doing a joint approach to this matter. We have a joint approach to this matter, and that's why you find, my Lord, that not every one of us makes submissions or presentations on every occasion.
I think while you could be correct, if I allow you, then there's no basis why I cannot allow the other side, because they could also just hang on that point. I think for clarity or purpose, I don't think it's fair to allow you to proceed.
Very well. We are most obliged.
My My Lord, I'll proceed with the re-examination of Dr. Gikonyo. Very quickly, Dr. Gikonyo, I'll refer you to paragraph 11 of your affidavit.
Yes, Your Honor.
On the reason why you filed the affidavit. Could you come clear or clarify why you saw this affidavit, referring to paragraph 11?
Your Honor, that is the way I understood it until I was made to understand that I had to understand other things of the Senate and other court matters. Because as far as I'm concerned, Your Honor, that paragraph summarizes why that I make this affidavit in my capacity as a medical expert, not a legal expert, in adult cardiology, to assist this honorable court in establishing that the first petitioner was duly admitted to hospital on the date in question, underwent treatment. That was my understanding.
And you had earlier confirmed that the contents of your affidavit were true?
Completely.
To the best of your knowledge?
Completely.
Thank you.
And I took a note on that.
Just to clarify a few issues that have propped up during cross-examination, and I will go back to paragraph 4 of your affidavit, and I'll be direct this time round because it cropped up. Is there any admission issues in paragraph 4?
None at all.
Thank you. So at 3 p.m. on 17th of October 2024, what exactly happened?
At around 3 p.m. is the word. Approximately is the word.
Yes.
If you want to know the exact time, it was 3:25. I have it.
What happened?
At around that time is when the petitioner arrived in hospital.
Thank you.
We took him in. We started the normal thing that we do for history taking his weight, blood pressure, and such. At that time, if you allow me to explain, is the time we start now the admission process.
Thank you.
And admission is a process, not an instant. And as we are doing those things, the accountants asking who is going to pay for this, blah, blah. And when they are ready, then they fix on the computer, this man is now admitted.
So when was he admitted?
According to our document here, 4:18 p.m. That is when the actual documentation of admissions were completed. These are technical details of timing and writing. Before that time, we are still seeing the client. We are doing the necessary things, but he's technically not admitted because the accountants have not allowed us to do that.
Thank you. I'll refer you to page 1 of 4 of the discharge summary. And on the top, the patient name is Mr. RG. Who is RG?
You know, Your Honor, if you come to hospital and you are an ordinary citizen, we put your full names and all your other names. There are clients we don't put names on record.
My Lord, we still object. That evidence is extrinsic to the record. It is inadmissible. And my good colleague here knows that question is also impermissible.
The question was actually raised in cross-examination, and what we are seeking is a clarification on who RG is.
And Your Honor, I have said, our practice in a hospital to protect privacy, because these documents go out to hospitals. The malaria parasite is positive, blah, blah, it's for so and so. We use codes.
Can you just
who is
ask him who RG is?
RG is the Honorable Gachagua.
Okay, is there any other identification information in that document? Have a look. Is there any other identification information with respect to that, without necessarily reading it out?
There's a mobile telephone number also.
Thank you. Would you confirm whether there is any discrepancy between the affidavit and DKG3, the discharge summary?
Not at all.
Thank you. And lastly, Is DKRG, what document is DKRG? Because there's been an allegation of a medical report. What is DKRG?
It's a discharge summary.
It's a discharge summary.
It's not a medical report. A medical report gives details that may not necessarily be required by this court. But if required, Your Honor, it's available.
And in your discharge summary, you were confirming what you deponed to in paragraph 11 on the purpose of the affidavit.
Absolutely, Your Honor.
Which is admission, discharge, and treatment.
Absolutely.
Thank you, Your Honor. That's all.
Just one very brief question, Dr. Gikonyo. It was put to you by Dr. Thionkulu that you admitted the petitioner, His Excellency Rigathi Gachagua, to hide him, suggesting he wasn't sick. And I think you responded by laughing. Now that you have finished laughing, will you please answer the question? Was Rigathi Gachagua sick or not sick? Were you hiding him in your hospital? Please answer. It is a serious question.
I must say I laugh because I thought it was not a serious question, because maybe it is not common sense. But however, the answer is yes, he was sick. We admitted him. We have data that's available to any medical person. We have medical reports. We have traces of his ECG, his echoes, everything, lab data that's available and available on demand by this court.
And apart from the documents, Dr. Gikonyo, you were here as the doctor, head doctor who was treating him.
Your Honor, that's why you called me, to answer those questions that I've answered to the family.
5th, a lot of October 2024. We will be relying on those documents, my lord. We will briefly highlight on a single issue, my lord and my lady, and that issue is the IEBC's involvement under Article 149 of the Constitution regarding vacancy of the office of the Deputy President. And the main question that we will be asking is whether the Constitution contemplates any role by the IEBC in the filling of that vacancy. My lord, Article 49 identifies two actors expressly. That is the President and the National Assembly. Therefore, the question that arises for this court's determination is whether, beyond those two expressly identified individuals, those two expressly identified actors, does the Constitution intend any additional role for any other actor, but for purposes of this submission, the IEBC? My lord, it is our humble submission that that particular article is deliberately narrow and precise by design. It provides two constitutional actors and two constitutional functions. First, the President, who nominates a person within 14 days. Second, the National Assembly. So on a plain reading, my lord, of that article, the Constitution does not introduce any third actor, any intermediary, institution, or any additional clearance mechanism where IEBC would play any particular role. And my lord, in answering this question, and because these submissions have been made severally
before this honorable court is what would have been or what could be the intentions of the drafters of the Constitution. And in asking ourselves this question, my Lord, we interrogated the harmonized draft and the Bomas draft 2004. Under Article 168 of the Bomas draft 2004, my Lord, the process was expressly confined to the President and Parliament. And while this process was a bit more complex than what we have in our present Constitution, involving both houses of Parliament, it still made no mention of the IEBC. When we move closer to the current Constitution that we have in the harmonized draft at Article 170, it is more similar to our Article 149. Again, there was absolutely no mention of any role played by the Electoral Commission at any point. Therefore, both drafts reveal that the drafters of the Constitution, sometimes we belabor too much on what the drafters intended. It could be easier to just reach out to Professor Gachagua and ask him what he intended. But it is clear from those two drafts that there was no intention to involve the Electoral Commission. Therefore, we ask ourselves, where could the qualms and the quarrel by the petitioner have arisen against the IEBC? And that would fall on one article of the Constitution. That is Article 148, the qualifications of a Deputy President. If you look at the qualifications of a Deputy President under Article 148, the Constitution references you to the qualifications of a President in 137, which further references you to the qualifications of a Member of Parliament, which is Article 99. My Lord, it is our submission that the petitioners proceed from an assumption that the IEBC must therefore undertake a formal verification or a clearance exercise as though the filling of a vacancy under Article 145 were an electoral process, which we humbly submit that it was not. My Lord, it is our humble submission that if there is any role that is not expressly stated or implied under Article 149, it would be to the two actors who have been mentioned in that article. That would be the President and the National Assembly, to satisfy themselves that the nominee meets the constitutional requirements of that office. My Lord, in that context, and seemingly out of abundance of caution, that we submit that the President sought factual information from the IEBC. And the IEBC merely responded with information that was within its custody, whether or not an individual is within the voter register. My Lord, we submit that up to that point, up to the point that the IEBC provided that information, it was not under any constitutional obligation or duty under Article 149. It simply provided information that it possessed. Now, my Lord, the other qualm that the petitioners seem to have is whether the information issued by the IEBC was improperly provided by a commission which was not properly constituted. My Lord, I humbly submit that this particular issue has been heavily argued before courts And there's several case law that demonstrate the roles played by the IEBC, either by the Secretariat or the Commission, or the Secretariat and the Commission. And we humbly submit one of those very important authorities, which can be found in our digest, is the presidential petition of 2022, E005, Raila Amolo Odinga and others versus the IEBC. My Lord, we submit that in that case, three distinct roles came out clearly. The IEBC possesses a role where the Constitution references, or where the legislation references the Commission. It could mean the Commission and the Secretariat, as was elaborated in that case, with the issue of verification and tallying. So a reference to the Commission could mean the Commission and the Secretariat. The instruction is to the Commission, but the action is to be taken out or to be handled by the Secretariat. And that can be found on paragraph 46 of that decision. Now, the second role would be that if legislation or the Constitution references the Commission, it quite simply means the chairperson and the commissioners. And that role is reserved strictly for the chairperson and the commission. And the decision went on to note that there are such roles that can be taken or handled by the Secretariat, such as this one, can we submit. My Lord, from that precedent, two principles clearly emerge from this binding authority. Number one, the Commission acts institutionally, not through personal involvement of the commissioners, in every function. It doesn't act through the commissioners in every single function. And that the Secretariat performs the day-to-day administrative and technical functions. So, my Lord and my Lady, the act that is complained about involves no deliberate decision-making by the Commission. It would not require any decision-making by the Commission. It requires no policy formulation, no exercise of constitutional discretion. It was purely factual and database driven, involving retrieval of information held in the voter register, verification of that information, that indeed the individual whom you sought information from is a registered voter, and communication of the same to the requesting party. I mean, IBC would do that of anyone. If you were today to request that information from the IBC, it would provide it easily. It did not have to have come from the President for the IBC to have acted and given the information. So that information could have come either way. My Lord and my Lady, I will point out three decisions that speak to the same. That is, I believe it is in our bundle of authorities, County Government of Uasin Gishu and two others versus the IBC, County Government of Kisii and two others versus the IBC, and County Government of Lamu and two others versus the IBC. Similar to this case, in all three cases, the position of Deputy Governor fell vacant for whatever reason. As is required by law, in all three cases, the Governor nominated an appointee to take up the position of Deputy Governor. The individual was vetted by their respective county assemblies. And during this period of time, the IBC did not have commissioners, three of whom having resigned, and the rest, three of whom having retired, their term having come to an end, and the rest having resigned.
the respective county governments wrote to the IEBC requesting that it gazettes these individuals. The CEO then, acting out of abundance of caution, felt that this was a role reserved for the Commission when it is properly constituted. And the courts, in specifically county government of Kisii and 2 others versus the IEBC, said that this is a merely administrative task arising from an already concluded legal process and is not dependent on the composition or quorum of the Commission. In county government of Uasin Gishu and 2 others, the court said that it is an administrative function of communication and notification, and the Secretariat is capable of undertaking that role. The court, and I'm going to quote the court directly, does not call for a commission to sit, deliberate, and come up with a decision. Therefore, my lords and my lady, I humbly submit that if these simple tasks of communication, notifying, giving information were to be subjected to the Commission, then the IEBC would lack purpose in a period where the Commission was not properly constituted and that there were no commissioners. Therefore, my lords and my ladies, we humbly submit that on those two grounds, that had been raised by the petitioners, that petition and those allegations fail as against the IEBC. My lord, I'll take a minute just to make reference to the prayers that were sought against the IEBC, specifically in the amended petition, that is prayer K. My lord, the prayer itself takes issue with the fact that the IEBC provided the said information. My submissions have completely covered that the IEBC plays no role. There is no constitutional role under Article 149. The only issue that arises, or that I haven't covered in the prayer, is the overnight clearance that violated Article 10 of the Constitution. And I have to say apologetically, my lord, that this prayer is absurd. My lord, IEBC is being complained of for efficiency, that we delivered information requested in a timely manner. I mean, that is what is needed of government. I have never seen a petition that comes to court to complain about the efficiency of an institution. My lord, I submit that there was no clearance. We were simply giving information that was contained in the voter register. I humbly so submit. Thank you very much, my lords.
Thank you. Thank you very much.
Yes, my lords and my lady, on behalf of the National Assembly, our representation is led by myself. We have Mr. Paul Nyamori, Mr. Alex Mbaya, Elias Ouma, and Mr. Crispus Kitala. My lords, to support our submissions this morning, we will rely on the affidavit of Samuel Joroge, dated the 21st October 2024. We'll also rely on the 2nd and 7th respondent submissions, dated the 17th of September 2027. We have, in addition to that, filed a list and bundle of authorities dated
17th September 2020.
2026, sorry. No, 2025. List and bundle of authorities dated the 17th of September 2025 as well. My Lord and my Lady, we fully adopt those written submissions. I will, my Lords and my Lady, start by making reference or drawing our attention back to submissions by learned Senior Counsel Professor Githu Muigai in relation to or on behalf of the Attorney General. I will borrow from his very able submissions on two critical aspects. Number one, on the nature of impeachment proceedings, and number two, on the jurisdiction of the court. In relation to the nature of the proceedings or the nature of impeachment proceedings, learned Senior Counsel Professor Githu Muigai describes those proceedings as proceedings sui generis and political, and he adds that this is not just in Kenya but globally. He then fortifies that position with two critical decisions. One decision is the decision of the Supreme Court of the Philippines, where the court says that impeachments are a constitutional measure designed to protect the state from official delinquencies and that it is political in nature. Locally, Professor Githu Muigai did refer the court to the case of Kawira Mwangaza versus the County Assembly of Meru, affirming that impeachments are inherently political and distinct from judicial processes. My Lord and my Lady, that being the position taken by the respondents, I then would want to trace the architecture of impeachment proceedings within the context of our Constitution. And I start with this point, my Lords and my Lady. Every 5 years, the people of Kenya go to the ballot to elect their leaders. In particular, and of most interest, is usually the election of the president, together with his deputy. Then, additionally, the election of parliamentarians. My Lords and my Lady, these elections determine or define the executive leadership and governance of a country. Now, central to the question of elections is the issue about the sovereignty of the vote. That under Article 1, Sabbatical 1 of our Constitution, the sovereignty is in the hands of the people of Kenya. It is for the people of Kenya directly making a determination who then choose who their leaders in those respective elective offices would be. That election, ordinarily, for context, is by secret ballot. And the reason why I say that is so that we understand that in the exercise of sovereign will, there is no need, there is no requirement for any Kenyan expressing their will to give a reason why they make a decision in the manner in which they make that decision. That is what in constitutional parlance, my Lords and my Lady, has been referred to as the power of we the people. Now, what is the significance of that election? The significance of that election is that it forms the basis of a social contract between the people of Kenya and their democratically elected leaders. That determination of governance or election of leaders is not without terms and conditions. Under our Constitution, my Lords and my Lady, the Constitution spells out in very clear terms what the expectations of the people of Kenya in relation to their leadership should be. Specifically, I draw your attention to the provisions of Article 10 of our Constitution. My Lords and my Lady, Article 10 of our Constitution, for some reason, has gained prominence over the years, since 2010, just on the narrow question of public participation.
But I want to this morning, my lords and my lady, draw your attention to the fact that under Article 10, the subtitle is National Values, and more importantly for the proceedings that we have before you, National Values and Principles of Governance. Article 10 then spells out, 10.1 spells out how it applies and how it's supposed to be interpreted and applied. My interest is drawn specifically to Article 10, Subarticle 2, which says the national values and principles of governance include, then there's A, B, C, and D. Now, those are not mere wishes. Those are the expressions of Kenyans saying that if you are to be a leader in Kenya, then you must lead on the basis of those values. I, for the sake of what is before us, draw our attention to Subarticle 10.2c, which talks about good governance, integrity, transparency, and accountability. Why do I say that? Because impeachments are founded on the basis of good governance, founded on the basis of integrity, transparency, and accountability. My lords and my lady, Kenyans, being fully cognizant of the high authority, high moral authority that they wanted from their leaders, did not stop there. They still, under Chapter 6 of our Constitution, went on to provide for 8 additional articles. The 8 additional articles, my lords and my lady, speak to the leadership and integrity of the leaders. The specific title, my lords and my lady, is Leadership and Integrity under Chapter 6. At Article 73 talks about responsibility of leadership. Of significance for purposes of our submissions today, I would want to draw your attention to 73.1, which says authority, responsibility, that is authority assigned to a state officer, is a public trust to be exercised in a manner that then the people of Kenya spell out what they expect of their leaders. Of interest to me is what appears at Subarticle 1A, Roman 3 and 4. Roman 3 speaks of brings honor to the nation and dignity to the office. At Roman 4 it says promotes public confidence in the integrity of the office. Chapter 6 then goes on to provide for many other ways of dealing with leaders at different levels of leadership within the country. Now, again, under that very Chapter 6, Kenyans then make it a cardinal and mandatory requirement that for any public officer to assume office, they must take an oath of office. Now, that oath of office is the epitomization of a social contract that I was speaking to. That oath of office, my lords and my lady, takes different forms depending on the office that one is supposed to be assuming. In the context of a president and deputy president, at Schedule 3, that is the third schedule, there is a very clear indication as to what that oath is supposed to be. It says, I, so and so, in full realization of the high calling, I underline high calling, I assume as the president or acting president or deputy president of the Republic of Kenya, do swear or solemnly affirm. The Constitution makes you to swear to the people of Kenya that I will be faithful and bear true allegiance to the Republic of Kenya. It also says that I will obey, preserve, protect, and defend its Constitution, this Constitution of Kenya, as by law established, and that all laws, together with all laws of the Republic, and that I will protect and uphold the sovereignty and integrity and dignity of the people of Kenya. I underline protect and uphold the sovereignty, integrity, and dignity of the people of Kenya. A similar oath of allegiance is provided for by the deputy president. When you get time, my lords and my lady, you'll take an opportunity to look at the nature of the oath. What is the significance of these oaths? My lords and my lady, we submit that it also creates public and moral binding commitment to uphold the sovereignty, integrity, and dignity of the people. And more importantly, that it is the accountability pledge in the social contract that I spoke to. At a later part of my conversation, or rather my submission this morning, I'll refer us to the consequences that the failure to adhere to these conditions or the terms of engagements would lead to in respect of leaders at one level or the other of government. Of interest, and just to show how significant the question of the integrity and this commitment to these articles, I mean the provisions of Article 10 and Chapter 6 are, the President, upon assuming office under Article 132 of our Constitution, is given a duty which is akin to reporting on how they are performing. Under Article 132(1)(c), which under the title Functions of a President, it says, once every year, report in an address to the nation on all the measures taken and the progress achieved in the realization of national values referred to in Article 10. It means a responsibility is put on the President or on the President to then report on the measures they've taken in the realization of Article 10. That just tells you how significant how important that provision is to the people of Kenya. Now, that defines to a large extent how the executive arm of our government works. The people of Kenya then do not stop at that. They say that in order that we hold you accountable, we must then have an arm of government that deals with or that keeps you on check, that exercises oversight over these elected leaders. Now, it is important to then make reference to Article 1, Subarticle 2, that the people of Kenya can make these sovereign decisions either directly or through their democratically elected leaders. So that then the source of authority for parliamentarians, for instance, is as a result of being the democratically elected leaders. And I'll speak to why that is important. I draw your attentions, my lords and my lady, to Article 93 of our Constitution. Article 93 of our Constitution establishes our parliament. That our parliament consists of the National Assembly and Senate. Now, at Article 94, the people of Kenya go on to determine what the role of parliament is. My lords and my lady, I am sure we'll have an opportunity to read the entirety of Article 94. But for purposes of a presentation that we are making before you at the submission, I draw your attention to the provisions of Article 94, Subarticle 2. It says, the Parliament manifests the diversity of the nation, manifests the diversity of the nation. It means that is where every single section or, if you wish, person or member of any class in Kenya is represented in Parliament. It takes into account the minority. It takes into account each and every community in Kenya. It goes on to say, it manifests the diversity of the nation, says, represents the will of the people. Read this in the context of Article 1, Subarticle 2, that Parliament represents the will of the people. That when parliamentarians speak, they do not speak as parliamentarians. They speak representing the will of the people. And more importantly, under that 94(2), and exercises their sovereignty. Again, read in the context of Article 1, Subarticle 2, it gives those people, the parliamentarians, the power to exercise the sovereignty of Kenyans. Now, this is a complete surrender in the constitutional sense, that Kenyans surrender their rights to their democratically elected leaders to be able to make decisions on their behalf. And from a craftsmanship point of view, one would want to argue that once we have elected our leaders, we cannot, every time we think there's an infraction of any aspect of a constitution, we then call Kenyans into a plebiscite. That is why we have leaders who then, in the event that there's such an issue, can speak for the people of Kenya. Now, I then draw your attention to the provisions of 94 94.4, that which says that Parliament shall protect this Constitution and promote the democratic governance of the Republic. Again, promote the democratic governance of the Republic. The Constitution then, under that Chapter 8, goes on in a slightly more granular sense at Article 95 to say, that is the role of National Assembly, to say the National Assembly represents the people of the constituencies and special interests in the National Assembly. In particular, I would draw your attention to 95, Sabbatical 5, which says, the National Assembly reviews the conduct in office of the President, the Deputy President, and other state officers and initiates the process of removing them from office. My lords and my lady, that article does not give us any option. It says the representatives will review the conduct of our elected leaders, separation of powers. If they find that any of the conducts does not fit within the confines of Article 10 and Chapter 6, then the instructions from the people of Kenya is very clear. Initiate the process of removing them from the office. Role of Senate at Article 96. I refer, my lords, to Article 96, Sabbatical 4, that the Senate participates in the oversight of state officers by considering and determining any resolution to remove the President or Deputy President from office in accordance with this, with Article 145. My lords and my lady, why is this important? It is important because we see a textual commitment, and this was a submission made by Learned Senior Counsel Githu Muigai. There's a textual commitment of this oversight responsibility to the parliamentary arm of government, that is the legislative arm of government. We then are drawn to, maybe just so that I conclude that, an explanation under Article 96. Now, this oversight is exercised in differently in different jurisdictions. In Kenya, the Constitution at Article 145 and Article 150 dictates that it is through impeachment. In other places, it is through a vote of no confidence. Both those processes, as submitted by Learned Senior Counsel and with the support of authorities, are political processes. That's why it is important for us that we appreciate the defining four corners of an impeachment proceeding and the role then subsequently of the court. I also add that the manner in which this legislative arm of government exercises its authority is by, number one, as well as in the proceedings before Senate. They deliberate, they interrogate, they question. After they've taken an informed position, my lords and my lady, they vote. That is how parliamentarians make their determinations. Now, that is how they express the will of Kenya. That is how they express the sovereignty of the people of Kenya. It then follows that a test that is to be applied in determining whether that exercise of that will and sovereignty was done properly can only be a political test, and I explain why. If we, for instance, conflate that test to be a test in the judicial sense, then the Article 10 and the values that it ascribes then immediately run into challenge. Because when we say, for instance, good morals, how will the court determine good morals other than by being subjective? There's no standard through which the court would say this is a good moral, this is a bad moral. That is why the people of Kenya say our elected leaders will determine that for us based on those specific provisions of the law. I want to give this in the context of Article 145, Fred Mutatis Article 150. Look at the grounds of impeachment, for instance, under Article 145. One of the grounds is that the existence of, or rather serious reasons to believe that the president or the deputy president, as the case may be, has committed an offense. Now, from a political perspective, the test is purely a prima facie test. I'll be looking at, having listened to what has been presented, what do I make of it? having heard what has been said, what do I make of this judgment from a morality perspective? If that same question was to be presented to the court, then there are defined standards. For instance, in relation to issues criminal, it is beyond any reasonable doubt. So it means those two tests, if we were to conflate them, then we will be judging a political process through what I would otherwise call a wrong lens. And that is, again, to be supported by the decisions in by the Supreme Court of Philippines, as well as the decisions in our own cases of the Court of Appeal in Martin Nyaga Wambora and 3 others versus the Speaker of the National Assembly, where the court says that courts have neither jurisdiction to initiate a motion, consider a resolution, nor hear charges against impeached officer. The province of the court is solely to decide on the rights of the individuals, not to inquire how Parliament performs its discretionary duties. I dare add, when a vote is presented to you, my lords, there is no requirement that a parliamentarian or a member of the National Assembly voting one way or the other assigns a reason as to why they voted, how they voted. That vote is assumed for all intents and purposes to be the expression of the people who elected that person to that National Assembly or to the Senate, as the case may be. That is the same position taken by the Supreme Court in the Sonko case, which is part of the decisions that we've cited in our bundle and list of authorities. The court then says, courts should be slow to interfere with the exercise of parliamentary discretion, and the mandate of the courts is restricted by the doctrine of a separation of powers to deciding on individual rights and fundamental freedoms. In other words, the processes that were undertaken by the legislative arm of government. Now, I want to draw inference just to make this point sink. Let's look at the provisions of Article 144, for instance, where the president could be removed from office for incapacity. Now, the process goes on. At the tail end of it, Article 144, Subarticle 8, yes, Article 144, Subarticle 8, the ultimate test is that the report of the tribunal shall be final and not subject to appeal, and if the tribunal reports that the president is capable of performing the functions of the office, the Speaker of the National Assembly shall so announce in the National Assembly. Now, what is important to draw here is that the people of Kenya are deliberate about saying these processes should be shielded from the court process. And that is the political component of these processes. And why is that important? We come from a history, my lords and my lady, where issues touching on the presidency have taken more than 5 years. In fact, we've had to go to subsequent elections when those matters were still pending in courts. Yet they are matters that are purely political in nature. My lords, for those reasons, the people of Kenya are very deliberate. It's not an omission. They're deliberate that they would want to omit the courts from that political process. Now, having outlined that constitutional architecture, we then draw our minds to how did we, or how did the National Assembly conduct the impeachment process that is the subject of this trial and this proceedings this morning. My lords, my lady, this is to be found in the affidavit of Samuel Njoro, 9 to 28. Now, at the test or the consideration that the court will be looking at is the manner in which the National Assembly complied with the provisions of Article 150, read with Article 145, mutatis mutandis. Now, number one, there's the question of establishment of the grounds. The grounds are under Article 145(1). I need not read them. What is important, though, is that once a member of Parliament presents a motion in the nature of Article 145, that is for impeachment of a president or a deputy president, as the case may be, then the Speaker of the National Assembly would have to satisfy himself on a number of threshold questions. I'll refer you to where this was done. Now, the first item that the Speaker looks at is whether, as framed, the grounds that have been presented in Parliament meet the grounds in Article 145. That is, I think, to be found in the Standing Order number 64.1, which defines how that motion is supposed to be made. It is supposed to, it says in a very general sense that it is supposed to be in writing, and number 2, it must spell out the grounds that are articulated in Article 145. Standing Order number 64.1A then goes into looking at the manner in which the Speaker reviews those grounds as to whether they fit within the constitutional architecture. And that is a role that is under those specific standing orders left for the Speaker of the National Assembly. My lords and my lady, I'll draw you and I'll probably point you in the course of my submission to the findings of how the Speaker of the National Assembly deals with those requirements. But the sum of it is that the Speaker of the National Assembly satisfies himself at page 745. Let me just try and get the page 745. As to the two tests, both under Standing Order number 64.1 and Standing Order number 64.1A, that both those conditions have been met. Now we go to the second test, and I'll take you just in a short moment to the Hansard to speak to this. We go to the second test, which is the threshold test. Now, the motion must be supported by at least, in the words of the Constitution, if a motion under clause, a member of the National Assembly supported by at least a third of all the members. So the first threshold test is that the motion is supported by at least a third of all the members. I'll draw your attention to how the Speaker of the National Assembly deals with that, determining that question. He makes an express finding that all the members refers to all the members elected, and he gives a specific number as to what all the members mean. He then gives a mathematical representation that for that threshold to be met, there must be at least 117 members supporting the motion that is presented. In the case at hand, my lords and my lady, the number of people who supported the motion was 282. 291, members of the National Assembly supported the motion presented by the member for Kibwezi. Now, the second test is under Article 145(2), which says, if a motion under Clause 1 is supported by at least 2/3 of all the members of the National Assembly, now the second threshold test under Article 145 Subarticle 2 is 2/3 of all the members of the National Assembly. Again, the Speaker of the National Assembly, at the conclusion of that exercise, makes a finding as to the number of people who supported or voted in support of the motion. In particular, they say 291 out of 349 members voted in support of the motion. That is what learned Senior Counsel Professor Gidu Muigai referred to as a super majority. My lords, in terms of compliance, those three thresholds are fundamental. I want to take a quick moment to just draw your attention to the specific area where this is to be found in the communication from the chair. Yes, I'm there, my lords and my lady. The Hansard runs from page 744 in volume 2 of the annexure SN3 of the affidavit of Samuel Njoroge. My lords, my lady, after identifying the specific issues of concern, the Speaker at page 748 says, Having examined the notice of a special motion by the member for Kibwezi West, I find the special motion meets the requirements relating to the form and threshold set out in Articles 145(1) and 151(b) of the Constitution and Standing Order 64. Then goes on to say, I have also satisfied myself that the number of members who have appended their signatures in support of a special motion exceed the minimum threshold of 117 members. Then further on it says, having determined that the special motion is admissible, let me now focus on the next step of giving notice to the special motion to the House. Understanding Order number 47, 4A, which provides that with respect to the motion of removal for the, from office, a member shall give notice of a motion in the House within 3 sitting days following the approval by the Speaker. Now, that, my lords and my lady, when you get an opportunity, is how the Speaker of the National Assembly deals with the threshold questions. We submit on behalf of the National Assembly that those thresholds were met. After meeting the thresholds, what then do we address our minds to? We stop there, my lords and my lady, to ask ourselves a number of questions that arose in the course of a presentation before you. Learned Senior Counsel Paul Mwite, supported by Counsel Mr. Kibe Mugai, Mr. Ndegwa Njiru, and even Mr. Ogada, described the pace at which the impeachment. Where does the pace, or what determines the timelines within which impeachment is supposed to be done? A reading of the entire Article 145 gives a total of 19 days within which the impeachment process should have been completed. And my lords and my lady, that said, if you calculate the 2 days, the 7 days, and whatnot, it gives you a total of 19 days. That said, my lords and my lady, the question of the timely and expeditious determination of an impeachment motion is a dictate of the Constitution. It is not a whimsical escapade or undertaking by the either National Assembly or the Senate. Those timelines are cast on stone, and they must be done within those timelines. Now, it is not unique when we're dealing with issues touching on the presidency because of the sensitivity of a presidency to a republic. Under Article 145 of 140 of our Constitution, any question as to the validity of election of a president is determined within 21 days. Again, under Article 144, a motion for removal of a president for incapacity is to be determined within 30 days. What do we read from these very tight timelines? We read the history that we've walked, that in dealing with these matters, which are obviously possibly divisive and also very contentious, if you leave parties to attend to those processes as they would, we would not be able to make those determinations within the contemplated timelines. My lords and my lady, that is the nature of our Constitution. Learned Senior Counsel Paul Mwite then also submits that impeachment is a nuclear option and should be the last resort in dealing with disciplinary issues around a presidency. I mean, around dealing with impeachment of a president or his deputy. My lords and my lady, contrary to that, Article 10 and Chapter 6, couched in very mandatory terms, speak to what I'd call the political hygiene of a country. They determine what follows. And remember, in the course of my presentation, I said I'll revert back to Chapter 6. At Article 75, my lords, 75(5) says, no, 75(3), sorry. A person who has been dismissed or otherwise removed from the office for contravention of the provisions specified in Clause 2 is disqualified from holding any other office. That is an important
dictate of a constitution. It doesn't give us an option. It means in black and white that to the extent that His Excellency the Deputy President was found to have been in breach of this Chapter 6, specifically the ones referred to Clause 2, which is to be read with Article 10 and Article 73. Once he is impeached, the Constitution says he is disqualified from holding any office. I underline any office. It is not just about the presidency, it is about any public office. And I think that answers the question that learned senior counsel posed to this court. It will be an office either at the national level, at the county level, at the constituency level, and I dare add, even at the county assembly level. Any office that is defined under Article 260 of our Constitution, the test being a simple one, will that office require that the payment to that office holder be made from the consolidated fund? So the long and short of it, my lords and my lady, is that this article is a bar, unless changed through any other process, is a bar to His Excellency the Deputy President from holding any office, any public office. I go to the next question around fair hearing. This was submitted to quite at length by my learned and good friend, Mr. Dudley Ochiel. I want to add that from a factual perspective, and this is available in the Hansard, each of the senators, each of the members of the National Assembly was presented with the volumes or the documents that contained the petition. The first respondent, His Excellency Rigathi Gachagua, then the Deputy President, was given an opportunity to respond, which, again, as you'll see from our Hansard, he very ably responded to in writing. He was again given an opportunity to attend in person before the National Assembly and before the Senate. Again, he seized that opportunity and attended. He did not just attend alone, he attended with a battery of at least 14 lawyers. That is what the law contemplates. Now, the lawyers were given an opportunity to ask questions, and the Hansard will bear me witness. I'll refer you to the specific aspects of the answer. That the lawyers representing the Deputy President then had very robust engagement, questioning each and every of the grounds that was represented or that was tendered for purposes of the impeachment. After that, the members of the Senate, just like in the National Assembly, were given an opportunity to ask questions. Why is that important? It is important because it shows that these two houses were given an opportunity to interrogate. An interrogation here is so that they're able to make informed decisions. My learned colleague Moses will address us at a later stage on the question of public participation. You will see how that public participation played in. The only point I would want to make is that when that public participation was conducted, it was conducted so that the members of the National Assembly and Senate alike could touch base with the people they represent to see what their thoughts were in relation to the question of impeachment. It is not for this court, I add. It is for the members of the National Assembly and the Senate, as the case may be. Now, is that a case of somebody who was not afforded an opportunity to be heard? My lord and my lady, that brings me to the central question in relation to that issue. The central question is in relation to the adjournment that was declined by the Senate. Let me say this. I will refer you to the provisions, or rather to the recordings in the Hansard, on how the application for adjournment was made by learned senior counsel Paul Muite. My lord and my lady, it is apparent from those proceedings that no ground or no evidence was presented before Senate to enable them, to support the exercise of discretion. With the material that was available before Senate, they made a determination on the basis of the fact, and they did ask this, that the proceedings before the House were time-bound proceedings. They put a specific question to learned senior counsel Paul Muite. What do you want us to do? My lords and my lady, I refer you to the specific answer that was given by learned counsel Paul Muite. Now, not a single piece of paper was presented to the Senate for them to be able to make a determination as to the allegation of ailment. Why is that important? It is important for this reason. The petitioners have come before you to try and question the exercise of discretion of the Senate in denying the motion or the application for adjournment. It is very clear that whilst in Senate, they did not tender any material to support that application. I underline any material. Learned senior counsel, the Honorable James Orengo, and this is captured in the Hansard, speaking to this same process, says at the very least, he would have expected at least a doctor from Karen Hospital to come and confirm to the Senate the condition of His Excellency, the Deputy President, then. That did not happen. That, my lords and my lady, we are seeing an affidavit emerging from the woodworks today. Of what probative value? If you're being invited, my lords and my lady, to evaluate the material that was before the Senate at the point at which they were making that determination declining the adjournment, what is the value of an affidavit being filed before you today to support that application? My lords and my lady, it must be abundantly clear that that application is not being made before this court. This court is merely being invited to review the manner in which Senate exercised its discretion. I dare add that absent any supportive material, then Senate had absolutely no basis of granting the orders that were sought. My lord, it should not be lost that even in Senate, and this is also evident in the Hansard, the petitioner, His Excellency, the Deputy President, then Rigathi Gachagua, was represented by a team of 14 lawyers. That is on record. My lords and my lady, are we saying that out of these 14 lawyers, none of them would have imagined that it is important to lay a document to satisfy the Senate or to give grounds for the adjournment that they were seeking? We think that is a far cry. That was a deliberate omission. This court cannot now go into looking for reasons that ought to have been looked at or items or material that ought to have been looked at by the Senate, but which were never quite placed before the Senate. It means that the affidavit that has been presented by Dr. Dan Gikonyo before the proceedings, to support the proceedings before you, is of absolutely no value because no material can be introduced. And I would equate it to the court proceedings. My lords and my lady, if I was to make an application before you today, my team leader, learned Professor Githu Muigai, is not in, and I just say, I want us to adjourn these proceedings, important as they are, then I tell you, I suspect that is unwell. Chances are for me to now go to the Court of Appeal to say that I now have a document 1.5 years after the application has been made. I want you to look at this affidavit. It confirms indeed that the person in issue was actually unwell. That material, having been missing in the proceedings before Senate, cannot be used as a basis of making a determination on that on the exercise of that discretion one way or the other. My lords and my lady, I would want to very quickly, I'd said I'll refer the court to various areas within the Hansard that speak to these items. In the third and fourth respondents' annexures, marked as Part 4, this big volume, unfortunately it's not paginated, they are the proceedings of the Senate, specifically at page 7, where Learned Counsel Paul Muite makes the application for adjournment, and it runs all through to page 15. My lords and my lady, I ask that when you get an opportunity, just read for yourselves and you see the deliberations as they unfolded before the Senate. There's then the communication by the chair of the Senate, which appears at page 15 after that of the same document. Again, the reasoning of the Speaker in relation to the question of adjournment, ultimately putting the matter for resolution by the whole House. My lords, that is the part of this Hansard which speaks to how the application for adjournment was made. I need not read the whole of it in the interest of time. I'm sure the court will find an opportunity to read that. I think I'd refer the court to the specific parts of the Hansard from page 744 of volume 2, annexures running from page 711 to page 1301, specifically page 744, running through page 746, up to page 749. My lords and my lady, that is how the National Assembly deals with the issue of the issue of threshold. Yes, my lords and my lady. So we then ask on behalf of the National Assembly that you find that the petitioners have not met the threshold for you to exercise the review that they're inviting you to exercise. I want to add, as I mentioned earlier, that the review that is supposed to be before you is a review of a determination arising out of a vote. Is it the sort of review that is contemplated in these proceedings? I say, or I add one point to that, that because the members of the National Assembly, the members of Senate, are not required under Article 1, Subarticle 2, to give the reasons as to why they voted however they voted, what would be this reason that would be testing if we were to apply a test, for instance, of Wensbury unreasonableness under the anisminic sense? There'll be no reason that we'll be looking at. From a political sense, my lords and my lady, the only solution left is by the people then saying that that specific member of the National Assembly did not express our will. We will deal with them in two ways. The Constitution says either you deal with them at the point of re-election or you deal with them through a recall, not in the manner in which we seek to want to, in a granular sense, lay blame on the findings of the members of Senate. I pray that the petitions be dismissed. May I now cede the ground to my learned friend, Mr. Mushemi, to make his presentation. I'm most obliged.
Thank you, my lords and my lady. My name is Michael Mushemi. I appear for the 9th respondent. Your lordships, we are relying on our replying affidavit dated the 22nd of October 2025. Our submissions dated 15th February 2026. Our supplementary submissions and list of authorities dated 5th of May 2026. And our further list of authorities dated the 12th of May 2026. Very briefly, my lords, since the enactment of the 2010 Constitution 16 years ago, Parliament has only met the threshold of 2/3 majority on any bill or any motion on 2 occasions. The first of these occasions was during the passing of the BBI bill, the now defunct bill, where on the 7th of May 2021, the National Assembly approved that bill with 224 members in support and 63 voting against. And in the Senate, on the 11th of May 2021, with the bill being passed by 51 members, 11 voting against and 1 abstention. My lords and my lady, my client, the 9th respondent, brought this motion pursuant to Article 145(3) and in historic numbers, first as required by the Constitution to garner 117 signatures, he was able to garner 290 signatures of members of the National Assembly to present this motion. And when the motion was tabled on the 27th of September 2024 and subsequently debated on the 8th of October 2024, as has been submitted by my learned colleague, Mr. Gumbo, the motion was supported by 282 members, representing 80% of the whole House. This was not just a majority, but a supermajority. When the motion went to the Senate and the vote was taken, and I'll only rely on one ground number 1, 54 members voted for the motion, 12 against, and 1 abstention. My lords, you have been told that Parliament acted as a lynch mob, but there has never been occasion in the 16 years that this Constitution has existed that Parliament has voted on such numbers. If that were the case, you would have been given instances or other examples where Parliament has acted in this manner. And the reason these numbers were achieved, supermajority in both houses, and you see that they exceed the BBI numbers. In fact, in the National Assembly, they exceed by almost 60 members of the National Assembly, is because of the weight of the 11 grounds of impeachment. My lords, it is our submission that in our country, there is no country anywhere in the world with a higher threshold of impeaching a president or deputy president in this case than this country. If you go to the United States, for example, in the House of Representatives, which is the lower house, you only require a simple majority to approve the articles of impeachment. It is in the Senate that you thereafter require 2/3. If you go to the Philippines, and here we are comparing presidential systems,
you require 1/3 of all the House members to endorse the complaints and 2/3 of the Senate. Nigeria has a system such as ours, and so does Brazil. So it is our submission that the safeguards provided by our Constitution are adequate to ensure that this process is not abused. Our Constitution further requires public participation, and this requirement now sets it apart from those examples that I have given you, where impeachment is handled solely by elected representatives. And as will be submitted by my colleagues, public participation was conducted across all constituencies in Kenya throughout this process. So in fact, my lords, we have no comparative in the world. We have the most progressive and advanced constitution in the world when it comes to impeachment of the president. The argument by the petitioners that either Parliament acted as a lynch mob is again not true. The argument that the Deputy President was elected by the people, whereas is true, the contra-argument is that he was also sponsored by a political party to run for office. He ran for office as Deputy President under the banner of a party called the United Democratic Alliance, UDA. And my lords, under Article 38 and under Article 91, political parties are the foundation of our constitutional democracy. In the National Assembly, at the time the Deputy President was being impeached, the UDA had 144 members of the National Assembly. Out of those, 114 voted to impeach the Deputy President, with 21 voting against. And it is our submission that it is clear that he had lost the confidence of his own political party to continue holding office. Our colleagues have cited numerous authorities from South Africa, and South Africa is a good example of how leaders respect decisions of political parties. President Mbeki in 2008 resigned after he was recalled by his own political party. He was not heard by the party. He was not invited to any hearing. The party just met and said they had lost confidence in him. This decision was submitted to him, and he said that he respects the decision of the party, and he resigned. The same thing happened to President Zuma, who resigned on Valentine's Day of 2018. And the following day, President Ramaphosa was sworn in. The party simply said, "We have lost confidence in you." Closer home here in Zimbabwe, when President Mugabe was removed as leader of ZANU-PF on the 19th of November 2017, again he opted to resign because he was going to face an impeachment vote. Parliament is often considered the highest form of representation in a democracy because it serves as a primary venue where elected members represent the diversity, will, and sovereignty of the people. It is our submission, Your Lordship, that the first petitioner not only lost the confidence of Parliament, but he had lost the confidence of the political party that sponsored him to run for political office. My Lords, you have been told a lot about the grounds of impeachment. And in Article 145, the framers of our Constitution and the context of our Constitution has to be read in its plain text. They gave 3 grounds for impeachment, and they said gross violation of a provision of this Constitution, and where there are serious threats of believing that the President has committed a crime, and for gross misconduct. There was very good reason for the drafters to give these 3 reasons, because they were not to subject the President or the Deputy President to judicial standards by members of Parliament. They were not to subject them to judicial standards. The charges against the Deputy President, 11 of them, are not to be subjected to judicial standards. I know my colleagues will give you examples of how other presidents have been impeached. But presidents all over the world have been impeached for far lesser crimes, for far lesser transgressions than you have seen here in our country. Here, the impeachment was on serious violations of the Constitution. I'll go to the grounds of the impeachment, my Lords. And you are told about subsidiarity. Ground number 6 of the impeachment, where the Deputy President was accused of crimes under the National Cohesion and Integration Act. Ground number 7, where he was charged with the economic crimes under the Anti-Corruption and Economic Crimes Act and the Proceeds of Crime and Anti-Money Laundering Act. And ground number 8, where he was charged with contravention of Section 29 of the Leadership and Integrity Act. You have been told that there should have been deference by the National Assembly to the institutions, that is NCIC, EACC, and the DCI, to allow them to investigate those crimes before Parliament could do the duty that they did. That is not true, and we are guided by a decision of this court by a 5-judge bench in petition number 295 of 2018, Philomena Mbete Mwilu versus DPP and others. This was a 5-judge bench, Justice Omondi, Justice Ngugi, Justice Tuyot, Justice Musyoka, and Justice Muita, delivered in 2019. And in this decision, particularly paragraph 379 of that decision, the judges go on to say, and this was a decision which the Deputy Chief Justice had challenged charges that had been preferred upon her by the DPP in the Chief Magistrate's Court. And the judges say that from the analysis, the following principles emerge. First, in the absence of an express statutory or regulatory provision requiring prior approval or sanction from another authority in order to prosecute a judge or judicial officer will face trial directly in the event that he or she is alleged to have committed an offense. However, and this is the second principle, where there is a specific legal framework for dealing with misconduct and or removal of judges, cases involving misconduct with a criminal element committed in the course of official judicial function or so closely proximate or linked to the judicial officer must first be referred to the body responsible and the disciplinary or removal process commenced. My Lord, it is our argument that this decision applies in this case. And the holding, in fact, was that while the DCI is not precluded from investigating criminal misconduct of judges, there is a specific constitutional and legal framework for dealing with misconduct and removal of judges. Consequently, cases of misconduct with a criminal element committed in the course of official judicial functions or which are so inextricably connected with the office or status of a judge shall be referred to the Judicial Service Commission in the first instance. Your Lordship, it is our argument that this applies even to the office of the President and the Deputy President, that where there is already a mechanism of disciplining them, then that mechanism ought to be exhausted first and not the other way around. In fact, our Constitution does not contemplate a situation where the President or the Deputy President would be facing organs of security which are appointed themselves by the President. And that is why the Constitution then provides this mechanism in Article 145 to discipline the President and the Deputy President and to hold them account through their removal by Parliament. This position was supported by several other authorities, and there is an article I will urge you to read, the temporary criminal immunity for federal judges, that is contained in that authority. Secondly, Your Lordship, the petitioners argued, particularly in relation to ground number 9, that the National Intelligence Service ought to be under a civilian supervision. And whereas that is true, Article 239 provides that it is one of the national security organs, the other two being the KDF and the National Police Service. And in fact, in the composition of the National Security Council, and there are 9 people who sit in that council, it is only the Deputy President who is not appointed by the President, meaning that the Deputy President is very central to the running of that council. Your Lordship, it is our submission on the issue of fair hearing that the Deputy President in the National Assembly, and Mr. Gumbo has taken you through this, was present. He was represented by legal counsel. And I think the place you need to dwell on most is the Senate. It is my client's case that, in fact, prejudice in the Senate was suffered by the 9th respondent and the National Assembly. And why do I say this? This is because the first petitioner was able to present his case and his documents. He was able, through counsel, to cross-examine witnesses of the National Assembly, including the 9th respondent. But when the time came to cross-examine him, he was not available. So the prejudice was not on him, because his evidence was treated without any cross-examination. And you see the result of the Senate, that in fact 6 of the grounds that the 9th respondent had presented through the National Assembly were not confirmed by the Senate. And the reason they were not confirmed was because the Deputy President was not cross-examined. Nevertheless, of course, any of the grounds is enough to seal his fate, but there was serious prejudice, not by the Deputy President, but by the National Assembly. On the issue of the committee route and the plenary route, our submission is that the plenary affords the whole House, and indeed the Deputy President, an opportunity to interact with the entire House, as opposed to the committee route, which limits the numbers. And remember, your lordships, the committee route is decided by the leadership of the houses. So if the leadership of the houses, the majority and minority, are working together, then they are likely to conspire to form a partisan committee. And therefore, actually, the first petitioner should be supporting a plenary route, which then exposes him to the entire House so that he's able to convince each one of them individually on the hearing. And that is why Senate, in its wisdom, elected to follow this route. My lords, you are taken by my learned senior Githu Muigai on Wambora and Sonko, and we rely on those decisions. But I want to mention briefly that there are two decisions that my learned senior Mr. Kibe Mungai talked about this morning. And one was just delivered last week regarding President Ramaphosa in South Africa, to constitute rules to be able to conduct impeachment processes. And those are two very progressive decisions. I thank Mr. Kibe for bringing them to the attention of this court. But the reason they are not applicable to our situation is because South Africa has only one chamber. We have two chambers here. We have the National Assembly, which acts the way the South African Parliament does, but we have a Senate to conduct the trial. So that decision is relevant to South Africa because they only have one chamber. And what the Constitutional Court was saying in EFF2 is that you need to formulate rules to be able to conduct impeachment. In this EFF3, which has been attached, the Constitutional Court is now saying that the independent panel report that was voted out by Parliament ought not to have been voted out, but taken to the impeachment panel. And that is precisely what our Kenyan system is, that you've had in the National Assembly, but you go for a trial in the Senate. That is the distinction between ourselves and South Africa. Your Lordship, on the issue of decisional independence of the judiciary, you have been told by the petitioners that that there was indeed a complaint filed in the Judicial Service Commission by the first petitioner, whereas that may be correct. If you look at the decision of Apollo Mboya versus Judicial Service Commission, petition number 204 and 218 of 2016, a decision by your brother Justice Korir, as he then was, this decision has talked very well about decisional independence of the judiciary, and if you get time to read it, you see that despite the first petitioner having filed a complaint in the Judicial Service Commission, it still did not warrant that he continues making attacks on the judiciary and the judicial officer in question. And that is covered very well in that decision. Therefore, Your Lordships and my lady, that is the humble submission of the 9th respondent. We urge you to dismiss the consolidated petitions. Thank you.
My lords, my lady, if it may please you in the matter. I appear, my lord, for the first respondent, as well as the 8th respondent, the Speaker, and the Deputy Speaker of the National Assembly. My lord, my lady, I will be very brief. The first ground that I wanted to handle, proceedings were fast-tracked, and on that I associate myself with the submissions of my learned colleague, Mr. Gumbo, that what the Speaker of the National Assembly did was simply to comply with the rules. Does not amount to expeditious or fast-tracked disposal of the proceedings. And my lord, my lady, we rely on the grounds of opposition that are dated 18th of October 2024, 20th of April 2026. My lord, my lady, I'm only left with one issue, which was alleged by the petitioners, that generally the Speaker was biased against the first petitioner. And I will demonstrate, my lord, that that allegation is indeed untrue and incorrect for the following reasons. Firstly, Lord, you shall note that the Speaker of the National Assembly does not participate in the proceedings of the House. The Speaker is merely a presiding officer of the House. And my lord, that is the dictate of the Constitution under Articles 97 1D and 107 1A of our Constitution. My lord, the views of the Speaker presiding over the House does not matter and has no influence to the proceedings in the House. And of importance, my lord, is that, as you've been told by my learned colleagues, impeachment proceedings are determined by a vote. And that vote is by members of Parliament. The Speaker of the National Assembly, at no point in time did he vote in these proceedings. In presiding over the House, my lord, my lady, the Speaker was undertaking a constitutional duty as prescribed by the Constitution. And under the standing orders of the National Assembly, the Speaker is expressly prohibited from voting. And although my learned senior, Paul Muito, have been a former member of parliament, knows this, but just for the record, allow me to refer the standing order that so states that position, and that is Standing Order 69 of the National Assembly. And allow me to read, my Lord. It states, that is Standing Order 69.1, states that unless otherwise provided under the Constitution, a question arising in the House shall be decided by a majority of the members in the House present and voting. Then 3 says, on a question proposed for a decision in the House, the Speaker has no vote. The Speaker, therefore, does not participate in the decision making. And in this case, my lady, it was unfair for the petitioners to complain against the Speaker presiding over the House. The second point, and there was an allegation that the Speaker was biased because he's a member of the Kenya Kwanza coalition, and that by virtue of that association, therefore, he ought not have presided over the House. My lady, my lords, you shall note that the mover of the motion presented the motion as an individual member of parliament. The motion was never presented by the Kenya Kwanza coalition. And it did not matter, therefore, that any member of the House was associated with any coalition in the House. And more importantly, my lord, my lady, the first petitioner himself is a member, or was a member, of the Kenya Kwanza coalition. And if there was any favor then that would emanate from association, then he ought to have been a beneficiary. The association of either party to the coalition, my lord, my lady, you shall note that did not have any impact, as the voting was across the board, both by the members of the Kenya Kwanza coalition as well as the Azimio coalition. So association, therefore, did not matter. But more importantly, the mere fact that the Speaker of the National Assembly is associated with a coalition in the House is not unique, and that in itself does not amount to a biased presiding officer. And I'll give examples, my lord, my lady. In Tanzania, the Speaker of the Assembly is also a member of parliament elected in a constituency. In Uganda, the same position applies. The Speaker of Parliament is also an elected member of Parliament. Again, in South Africa, my lord, the member of Parliament is elected as a Speaker of the National Assembly. And that applies everywhere, including even in the Kenyan Senate. The Speaker of the Senate is associated with a political coalition. And therefore, it's not unique for the Speaker of the National Assembly to be or to have association with a political party. He enjoys his right to participate or associate with a political party. The third allegation, or rather the allegation also about him being a biased presiding officer, you shall note that that allegation was never raised when the impeachment proceedings were presented before the House. That issue only arose when the pleadings were filed before this court. Yet, we've been told here that the first petitioner was represented or was accompanied by a battery of lawyers who appeared with him before the House. The raising of this issue, therefore, before you, my lady, my lords, is an afterthought. It's just for the mere so, but without any consequences. The other point I wish to raise on that, my lords, my lady, is that the Speaker of the National Assembly never commended on matters relating to the impeachment proceedings before or during the impeachment proceedings. He never made any comment whatsoever. His position was and still remains that he had no fight, he had no dog in the fight. He had absolutely no interest in the impeachment proceedings, and it's therefore unfair for the petitioners to complain for him merely having discharged his duty to sit as a presiding officer. The other complaint or issue that was raised about his biasness was in reference to a constitutional petition that I argued with my learned colleague Kibe, petition E202 of 2023, my lords, that had stated that the Speaker ought not be a leader of a political party. My lord, my lady, you shall note that that was not the ratio of that judgment. It was indeed an obiter, as it never formed part of the findings of that decision. But more importantly, the petitioners in that case had sought expressly that the Speaker be barred from presiding over the proceedings of the National Assembly, and that he again be removed as a Speaker of the National Assembly. All those prayers were dismissed by that court. None of them were granted. And in that decision, the Speaker of the National Assembly was never stopped from presiding over the proceedings of the House. And it therefore cannot be invoked as a decision to show that there was bias on the part of the Speaker of the National Assembly. Just to add, my lords, my lady, is that there's an appeal pending against that decision in the Court of Appeal, and we will be sorting ourselves out on that matter. The other point, my lady, that was against the Deputy Speaker, you shall note that the Deputy Speaker at no point in time did she preside over the proceedings relating to this impeachment. She never sat as a presiding officer. Her decision in respect of this matter was made through a vote that she was entitled to do as a member of Parliament. Her views, therefore, whether for or against the impeachment proceedings elsewhere, could not have an impact in the decision that was taken by the House. And more importantly, my lord, my lady, is that none of the members of Parliament complained that the views of the Deputy Speaker influenced the decision that was made by way of voting. Another point that I would invite the court to consider is that there's no prayer in the entire petitions that has been sought against the Speaker and the Deputy Speaker. Their involvement in these proceedings was for the mere so. And if it were that then the petitioners were true, that they had an issue with the Speaker and the Deputy Speaker, they ought to have sought a prayer against them. There's none whatsoever before you. What the petitioners are doing, my lord, my lady, is that they are shooting in the dark with a name that somehow they'll hit the target. Unfortunately, the Speaker and the Deputy Speaker cannot be a target in these proceedings because they had no fight. There's no dog in the fight. My lord, lastly, you realize that these are the same petitioners that had filed recusal applications against this court. And indeed, they had raised issues of bias.
What's the relevance of that line of argument?
I wish my line colleague would have waited so that I showed the relevance. My lord, that is a decision which is part of the record, and I don't need to cite it.
Sure.
All I was saying, my lord, my lady, is that the standards of recusal have already been established by this court in its recusal application and upheld by the Court of Appeal. And that the mere mention of the word bias, a four-letter word, and association by a party does not in itself constitute a reason to ask a presiding officer to recuse him or herself. And that same reasoning, my lords, my lady, ought to apply here. And we seek that you find the allegations that have been laid against the Speaker and the Deputy Speaker to be without a basis, and they be dismissed. We associate ourselves with the submissions of our learned colleague for the respondents and the AG seeking that the petition be found without merit and that it be dismissed. That will be all, my lord, my ladies. I thank you.
Not yet, my lord. For the National Assembly. Very well, my lord. My name is Elias Ouma. I'll address you on two straightforward issues, namely, whether the sub judice rule under Standing Orders 89 of the National Assembly and Standing Orders 103 of the Senate could be interpreted to bar parliamentary proceedings on impeachment where judicial proceedings are still pending. My lord, from the very outset, it's our firm position that this court could not and should not interpret Standing Orders 89 of the National Assembly and 103 of the Senate to bar the National Assembly from deliberating impeachment proceedings in the disguise of sub judice rule. My lord, we take this position based on three arguments. First, the very Standing Orders is not absolute rule. The very Standing Orders that provide for sub judice is not absolute. Neither is it automatic. My lords, my lady, the Standing Orders establishes a two-limbed threshold which must be satisfied conjunctively for the same to be invoked. My lord, for clarity, permit me to read Standing Order 89, 1 and 2 of the National Assembly, which is pari materia with Standing Order 103 of the Senate Standing Orders. My lady, my lord, under 89.1, the sub judice rule is established. More critical to note is its applicability and its definition under 892. It says, a matter shall be considered to be sub judice when it refers to active criminal or civil proceeding and the discussion of such matter is likely to prejudice its fair determination. My lord, from that text, the word "and" is carefully crafted. It is deliberate and restrictive. It provides a mandatory conjunctive element that for the preceding statement to ensue, then the petitioners ought to have established a level of prejudice. My lord, why do we say so? The Court of Appeal, and this is a decision we have cited in our supplementary list and digest of authorities, in Korir versus Republic, Criminal Appeal number E52 of 2023, had a chance to define the meaning of the word "and" when used in a statute. My lord, if you go through that decision,
You will note, and with reference to this standing order, that for sub judice rule under 89 to be invoked, there must exist an active proceedings before a court of competent jurisdiction. Secondly, and more critically, there has to be a demonstrable likelihood of prejudice. Who then has the burden of proving this prejudice? And that takes me to my second argument. My lords, my lady, it's our submission that the petitioners at the time of trial in the Senate and the National Assembly had the burden of providing, by way of evidence or demonstration or through a preliminary objection at the National Assembly, at a preliminary stage, the level of prejudice to demonstrate that the discussions and the debate on impeachment could actually impair administration of justice in the impending cases. Worth noting, my lords, my lady, in your previous ruling, this very bench provided the remit within which this court can intervene during impeachment. Those decisions are your decisions. And that's the reason why this issue was not raised in the National Assembly. And to my third and last argument on this issue, my lords, before that, my lords, it's important to note for clarity that a cursory glance of the Hansard, and that is marked SN13 in our affidavit by Samuel Njoroge, that issue was never raised. It was not raised. And to my last argument on this issue, it's our submission that standing orders ought to be interpreted purposively and in a manner that gives full effect to parliamentary autonomy and the constitutional doctrine of separation of powers. As submitted by my learned senior and pupil master, Mr. Eric Gumbo, under Article 95(5) of the Constitution of Kenya, it is the National Assembly, not courts, not executive, not commissions, that has the mandate of initiating the process of impeaching the Deputy President. What does that mean, my lords, my lady? Under the doctrine of separation of powers, the rubrics of doctrine of separation of powers, and this has been cited in our list and digest, the Supreme Court in Mate, Justice Kariuki Mate and another, versus Martin Nyaga Wambora and another, 2017 EKLR, at paragraph 63. The court set the parameters within which various state organs must function. It provided 5, but of critical is number 3. The court said that each arm of government is under duty to refrain from directing or interfering with another organ on how to exercise its mandate. To the extent that the issue of impeachment and initiation thereof is a preserve of the National Assembly, then this court should not be invited, in disguise of sub judice rule, to interfere with the functions of the National Assembly. My lord, any contra-interpretation would allow litigants in future to weaponize the judiciary to protect public officers who should be accountable as submitted by my pupil master and who should be held accountable under Article 145 of the Constitution. Because of time, my lord, my lady, I'll take you through the second issue, which is also rather straightforward and raised by one of the petitioners. That is whether the participation of Honorable James Orengo, Senior Counsel, as sitting governor, and Honorable Tiende Amolo, Senior Counsel, as member of the National Assembly, created a conflict of interest and undermined the fairness of the impeachment proceedings. My lords, my lady, first, it's our submission that there is no constitutional or statutory bar that will prevent an otherwise qualified advocate to represent a party either in court, tribunals, or quasi-judicial commissions. The only exemption that exists is where there are conflict. As submitted by Manad Senior, conflict requires evidence. Conflict must be demonstrated. It's our submission that the petition has failed to demonstrate by way of evidence that the participation of Honorable Orengo and Honorable Tiende Amolo would prejudice and or result to an impaired proceedings during impeachment. More important to note is that this very issue has been determined by a court of equal status in John Okello Nagafwa versus Independent Electoral and Boundary Commission, 2013 EKLR. What did the court say, my lord? The very subject individual was subject of that petition, that is Honorable Orengo. At paragraph 27, this is what the court said. The petitioner has not demonstrated before this court that Orengo has used public time in preparing for and participating in this election petition. No evidence has been shown to the court demonstrating that counsel's conduct this far is inherently incompatible or fundamentally in conflict with this role as a member of Senate. My lord, it is the petitioner's contention that the participation of these state officers contravened Article 77 of the Constitution. What does Article 77 of the Constitution say, my lord, my lady? Article 77(1) says that a full-time state officer shall not participate in any other gainful employment. My lord, to give effect to this provision, Parliament enacted Leadership and Integrity Act. That act was repealed, but it was in operation at the time of impeachment of one Rigathi Gachagua. My lords, my lady, under section 26 of that act, there is a definition of a gainful employment, and for that provision to apply, there's a condition that must be demonstrated by the petitioners. And that is section 29(2). It defines gainful employment to mean work that a person can pursue and perform for money or other form of compensation or remuneration. And this is where it's important to note, which is inherently incompatible with the responsibilities of the state office or which results in impairment of the judgment of the state office. The petitioners are saying that the participation of Honorable Orengo resulted to gainful employment. But they have not given you any evidence to show how it impaired the judgment of these state officers. My lords, my lady, it is the rule of the thumb that he who alleges must prove. All the petitioners are saying are speculations, and they are not anchored on any basis. On that ground, we urge you to dismiss their issues as raised in their petitions. I'm most obliged, my lady.
I think before you sit down, the citation you were given about Senator Obaiko, I think you picked and chose what you wanted. There are better opportunities for that issue.
Yes, my lord.
Look at the case of Manduku versus PPP. I did it myself and I made comments on that. I think we owe it to the court. Although we are not bound by our decisions, we should be. We should be candid enough to say that there's also another case where some issues arose, and this is what the court said.
Yes, my lord. Just to distinguish that, my lord.
Why did you not say about the
I'm much glad, my lord. Most obliged, my lord. Most obliged.
It's 2 o'clock. I think we should take a rest and then come back at 3.